The top of the day to you, ladies and gentlemen. I have a question for you before I proceed. Have you ever had yourself in a situation where you have an issue with a telecommunication network service provider, such as an MNO? Examples being MTN, Glo, Airtel, Nine Mobile, etc. And you're in a dilemma on the next course of action to take to resolve this issue. Have your mind at rest because I will be speaking on consumer remedies for poor quality of service under Nigerian Telecommunications. I am Taiwo Adedamola, a 400 level law student from Leeds University and an undergraduate law intern at HARLEM solicitors. Rest assured that before the end of today's video lecture, you would have your horizon broadened on the concept of telecommunications, law that regulates telecommunications, law that regulates consumer protection, who a consumer is, when a contract is deemed to be existent between a consumer and a telecommunications service provider, rights of a consumer, and processes by which a consumer may seek remedies. What is telecommunication? Telecommunication can be defined as the transmission of information, data, or signal using electronic or electromagnetic waves. According to the International Telecommunications Union, telecommunication is defined as service provided or services offered by telecommunication service providers. What are the laws that regulate telecommunications? The principal regulator of telecommunication in Nigeria is the Nigerian Communications Act 2003, hereinafter referred to as the NCA 2003, which has duly established the Nigerian Communications Commission, known as the NCC, to oversee the enforcement of the NCA 2003 as related to telecommunications. What laws then regulate consumer protection in Nigeria? I'll start with the Quality of Service Regulations 2013, the Federal Competition and Consumer Protection Act 2018, the Dispute Resolution Guidelines 2004, and the Consumer Code of Practice Regulations 2007. What then is a consumer, or who is a consumer? Subject to the provision of sections 157 of the NCA 2003, a consumer is anyone who uses or subscribes to a network service, and as such, he has the following rights, subject to the provisions of Regulation 6 of the Consumer Code of Practice Regulations 2007. He has the right to be informed or right to information, such that such information must be adequate, it must be complete, it must be up to date, and such information must be clear in the language that the consumer understands. A consumer also has the right to the protection of private information or personal information, such as name, the date of birth, the NIN, which was used in registering a SIM card with the telecommunication network service provider. And as such, the telecommunication network service provider has a duty to protect such information and shall not release it to the public without the consent of the subscriber. A consumer also has the right to adequate billing, such that it shall not be subjected to indiscriminate billings and it shall not be made to pay for services that was not rendered to him. Subject to the provisions of sections 104 to sections 106 of the NCA 2003, a consumer has the right to good quality of service, and any telecommunication provider which acts in contravention of that provision shall be deemed to have infringed on such rights, the right to good quality of service of the consumer. In this case, when it comes to seeking remedies, sections 4P, in tandem with the provision of section 73 of the NCA 2003, has provided that the NCC shall have the power to regulate or to resolve disputes between consumers and telecommunication network service providers. And as such, subject to section 74, the consumer must ensure that he has made an attempt to resolve the issue by means of mediation or negotiation with the telecommunication network service provider. And pursuant to section 75, NCC may then receive a complaint from the telecommunication network service provider. As held in the case of Adiola and Adioba, the court held that where a telecommunications network subscriber has not exhausted a mode of action provided by the statute, such telecommunication network subscriber cannot bring an action to court. As also held in the case of Abubakar and Nazamu, the court held that where a mode of action has been prescribed by the statute, the telecommunication network subscriber must follow such, and any act done otherwise shall be deemed a nullity. Now you may ask, what court has the jurisdiction to hear telecommunications matter? By virtue of sections 157 of the NCA 2003, the Federal High Court has the jurisdiction or exclusive jurisdiction to hear telecommunications matter, also provided in sections 251 of the 1999 Constitution of the Federal Republic of Nigeria as amended. However, it should be noted that by virtue of the case of Adeleko and ECU line, the court held that where a case is grounded on simple contracts, such shall have the jurisdiction, or the state high court shall have the jurisdiction to hear such matter. And also, it means that when there's a dispute between MTN and the subscriber, the state high court shall have the jurisdiction to hear such matter. However, in an instance where two telecommunication operators have disputes, the federal high court shall have the jurisdiction to hear such matter, and where a government organ such as the NCC has the dispute with a telecommunication network service provider, the federal high court shall have the jurisdiction to share such matter. Conclusively, if it can be provided or if it can be established that the telecommunication subscriber has fulfilled the conditions precedent, then it can bring an action to court. For more information, follow our social media handles on Instagram, Twitter, LinkedIn, Facebook at HARLEM Solicitors, and visit our webpage or website at www.harlemsolicitors.com. Thank you very much.